Across the nation, the battle over abortion rights continues. A Louisiana state court judge has blocked the state's trigger law banning or severely restricting abortions. This comes after abortion providers in that state filed a lawsuit arguing that abortion restrictions violate providers' due process rights. And other state courts are dealing with new cases. A Utah judge has blocked for 14 days Utah's near-total abortion ban from going into effect. This 14-day period will allow time for the court to hear challenges to Utah's trigger law. And today in Texas, a judge ruled that abortions up to about 6 weeks in pregnancy can resume. A further hearing on that matter has been set for July 12th. So will others follow suit in challenging these abortion bans? I'm joined by Mike Davis, former law clerk to Supreme Court Justice Neil Gorsuch. Nice to see you, Mike. And I should say that you're not clerking now with this decision that came down, right?
I am not clerking now.
Okay, good. Now tell me, the debate continues, but these are temporary orders from these courts, a temporary restraint. And why are they temporary? They
are temporary because the states are looking at injunctive matters to decide whether these abortion laws violate state law. The U.S. Supreme Court has already ruled in Dobbs that Roe versus Wade is overturned and there's no longer a federal constitutional right to an abortion, and now they're trying to decide on a state-by-state basis whether there is a state constitutional right to an abortion.
These are temporary restraining orders. Does that indicate that either they're how they might likely rule, or does it indicate instead that because they don't want to change the status quo because there could be an impact on somebody?
Well, it could be both, Greta. As you know, as a lawyer, there's a likelihood of success on the merits when you're dealing with these restraining order issues, even TROs at the state level. So these judges are indicating that they're going to rule that there's a likelihood of success on the merits under the state constitution. But again, federal constitution is no longer at play.
You know, it's interesting. I mean, we've seen what's happened at the homes of Supreme Court justices. Now these local trial court judges, they're thrown into the fire.
They are thrown into the fire. I think people need to understand that when you're protesting, when you're intimidating judges outside of their home, not only is it a violation of federal law to intimidate federal judges outside of their home, 18 U.S.C. 1507, obstruction of justice, it also puts the justices in grave danger. We saw this with Judge Esther Salas, an Obama appointee federal judge in New Jersey who had her 20-year-old son Daniel murdered and her husband Mark seriously wounded in their home. This is a dangerous game. It almost led to Justice Kavanaugh's assassination in his home with his wife and 2 young daughters. So I think that people need to leave judges alone in their homes.
You know, you wonder who's going to want to be a judge. I mean, you get to walk around, people say, Your Honor, you know, at the grocery store, I suppose, and in the courtroom. But, you know, it's become dangerous. There was also the one in Chicago a number of years ago, a female judge whose family, or I think her mother and husband were murdered. But, you know, I wonder how many people are going to sort of look, you know, not choose that as a career path.
Yeah, and it also just happened to a Wisconsin judge. I would say that the Attorney General, Merrick Garland, it's a complete dereliction of duty that he is not sending the FBI to enforce 18 U.S.C. 1507. You do not have a First Amendment right to go to a federal judge's home and intimidate that judge and their family over a pending case. That is.
What about after it's over? I mean, so let's look at it. That statute. It says you can't go there to intimidate, but if the decision's already over and done, you're not intimidating much. It's done. Well, now you're just being obnoxious, maybe, or practicing your First Amendment right.
There was a Supreme Court case 50 years ago that upheld one of these laws on constitutional grounds, on First Amendment grounds. This is a narrow time, place, and manner restriction. And think about it. If you think that you're going to be harassed after you rule versus before you rule, there's still intimidation.
You're right. That makes a good point. All right. The leak. That's unheard of. I mean, we were all shocked. Were you shocked to find out there was a leak of that draft opinion?
I was stunned. I clerked for Justice Gorsuch on the Supreme Court. I clerked for him on the 10th Circuit. I have never heard of a Supreme Court draft opinion leaking, and they need to get to the bottom of this.
All right. Now, a lot of people think that it's a clerk. Is it possible it could have been left on a desk and somebody else leaked? I mean, people are pointing fingers at liberal justice's clerk, which we have no proof of. But who has access to draft opinions?
It is a very limited universe of people who has access to these opinions.
All right. The clerks, the justices, who else?
There are 2 to 3 administrative aides in each set of chambers who have access to these draft opinions, along with Marshall's aides, who in the Supreme Court, they walk them around old school style paper. So they could have had access. The issue is the political story that leaked this draft opinion also included the internal deliberations of the justices that only the justices or the law clerks would have known.
All right, so it's not like, is there a printing office in the Supreme Court?
There is.
So, okay, so it's got printed someplace.
Well, the drafts don't go to the printing office.
Well, it looked like it was a printed. It looked pretty official.
Well, it could have just been the official template that they use in chambers. So it's almost certainly a clerk who leaked this because there were 2 leaks. There was actually 3 leaks with Politico. There was the draft opinion that leaked, the Dobbs opinion. There was the analysis that leaked with that draft opinion, and then there was a follow-up leak with the same reporters at Politico.
You know, the bad thing about, from my perspective, is that, it really takes away a lot of respect, I think. There are a lot of problems. The court's is under siege anyway now, but when that happens, it takes away a lot, at least, I think, what people think about the court.
Yeah, I mean, and maybe that was the intent of the person who leaked this, because this person was not happy that the Supreme Court was going to overrule Roe versus Wade and return abortion regulations to the states. And maybe this clerk presumably did that because they wanted to destroy the court, destroy the court's reputation.
I could make an argument, too, that it could be leaked by somebody who just wanted to be like a big deal or something, and even on the right-hand side of the spectrum. I don't know. Anyway, nice to see you. I hope you come back.
Thank you.